Hi, good evening, ladies and gentlemen. My name is Yazdi Tantra, and I am the founder of Consumer Resources and Online. It is our proud privilege to be associated with Zerick Dastur to bring you this webinar on Red Zone for contracts, commercial contracts, and challenges arising from the COVID-19 pandemic. Zerick Dastur practices in the field of court litigation, dispute resolution, arbitration, and securities law. He is a triple gold medalist from Mumbai University. Zerick's practice covers diverse areas of corporate, commercial, and regulatory disputes. He is representing a number of clients in the manufacturing, engineering, port, infrastructure, and mining sectors. Zerick has represented clients in domestic and international commercial arbitration matters. Zerick's practice involves representing clients before various courts like the Supreme Court, High Courts, statutory tribunals, and regulators, including the Securities Appellate Tribunal, the Securities and Exchange Board of India, SEBI, the NCLT, CCI, etc. Zerick was a former partner at the law firm J. Sagar and Associates. He has been involved in a number of matters involving issues of constitutional law, contract law, and arbitrations. Zerick writes for various national newspapers and publications on corporate, commercial, and competition law. He is a regular speaker at events organized by Economic Times, VC Circle, Indian Merchant Chambers, Corporate Knowledge Foundation, and the World Zoroastrian Chamber of Commerce. He is a member of the Law Committee of the Indian Merchant Chambers. Ladies and gentlemen, here I present to you Zerick Dastur.
Speakers who will give you a business perspective of things firsthand. So these are speakers from the business side who I've had the pleasure of working with in the past, who will give you a very brief outline as to what issues their companies are facing, because many of you may resonate with what they have to say, and accordingly, people may benefit from their perspective as well. After that, I will take your questions, which will be, as Mr. Tantra indicated, put up in that chat box, where you can put in whatever questions you have, even while I'm speaking, in the chat box, so that after the other two speakers have completed, I will take your questions and try and answer as many as possible within the given time frame. So without any further delay, let us go directly into the topic of legal impact of COVID-19 on commercial contracts. So before we start, I think one fundamental principle for everyone to keep in mind is there are two aspects which will govern this discussion. One is the contractual aspect, and second is the legal aspect. When we discuss the contractual aspect, we will talk about the concept of force majeure and the force majeure clause, which is there in most of your commercial contracts. And when we discuss the legal aspect, we will be discussing with live examples and cases the concept of frustration of contract, which is a purely legal concept independent of the contract, which is also relevant in the current times, looking at the situation which we are dealing with. So just to give you a flavor, the statutory framework governing our discussion is contained in the Indian Contracts Act in two sections. One is section 32, which is talking about contingent contracts, where a contract is depending on a contingency. And if that contingency happens, only then that contract will be enforceable. And if that contingency does not happen, the contract will not be enforceable. The second, section 56, talks about impossibility of performance, where it becomes impossible for a contract to be performed after entering into the contract for certain supervening circumstances which are not envisaged at the time of entering into a party. It is completely independent and dehors the contract, where situation happens which is unforeseen after entering into the contract, which can discharge the parties from the rights and obligations under the contract. So to start this discussion, we will first discuss the concept of force majeure and the force majeure clauses which can be found within the contract. When I started my legal career, I was told by a very eminent lawyer that there are two kinds of lawyers. One, the preventive lawyers, who are the transactional lawyers, and two, who are the curative lawyers or the dispute resolution lawyers. So the preventive lawyers or the transaction lawyers, they are into drafting of contracts and documents. So their job is to draft robust agreements so that they minimize the possibility of going into dispute, and in case they do go into dispute, they maximize the chances of your success by drafting crystal clear, robust clauses which govern the contract between the parties. The second, of course, are the curative lawyers. You go to a doctor when things go bad. So they are the litigation lawyers or the dispute resolution lawyers who take your cases before the courts. They appear before the courts, arbitrations, and try and resolve disputes. So when we discuss the force majeure clause, the role of preventive lawyers becomes very important, because it is important to draft all encompassing exhaustive force majeure clause which can deal with as many possibilities that can be envisaged at the time of entering into the agreement. So just to give you a brief perspective, there are four fundamental elements which each of which we will discuss to a force majeure clause, which in their own capacity have an equal importance and have to be kept in mind while drafting and incorporating a force majeure clause within your contract. So these four, they start number one with defining a force majeure event, which is basically a trigger event like a war or an act of God, which will trigger the force majeure clause. Number two is the manner of invocation of the force majeure clause by way of a notice which can be issued to a party. Number three, and probably the most important aspect for our discussion today, is the clause which talks about the consequences of happening of a force majeure event. So they will talk about what will happen, how would the rights and liabilities of parties devolve upon happening of a force majeure event. And finally, there's a part of that clause which talks about mitigation. It is a bounded duty of every party to try and mitigate the losses which can happen in such a situation, and to take all possible steps and measures to mitigate the damage. So this is the fourth aspect which can be discussed. So going into a slightly more detailed account, the first aspect, which is the force majeure event, which we are discussing, is normally external aspects such as war or a strike or a natural calamity or a lockdown or an epidemic, a pandemic, or any such other similar situation or circumstance beyond the control of the parties, which renders performance of the contract difficult or hinders the performance of a contract. So normally what you have, as you may have seen, in a number of force majeure clauses, which is a purely contractual right, parties can discuss and frame the contract the way they want to. So you will see specific words such as war, strike, lockdown, pandemic, and followed by general words, such other circumstances beyond the control of parties. So you can make the clause as exhaustive as possible, because as I said, this is a contractual right. If this eventuality happens and it is covered in your contract, then it is easy to enforce that. For instance, the COVID-19, if your force majeure clause covers an aspect of a pandemic or a natural calamity, then you can directly rely on that clause and you can cover that particular aspect, which will determine your contractual obligations during that period of time. So here we come to the concept of that omnibus general clause, which follows these specific words, which is such other circumstances which are beyond the control of the parties, and how courts will interpret that. So that's why what I recommend is to try and make the clause as exhaustive as possible, to try and put in as many situations that you envisage. Obviously, it is not possible to contemplate and provide for everything, but to the extent possible, if you provide, you don't render it to the susceptibility of some judicial interpretation as what will be the outcome of that clause. So I will give you a legal principle as to how a court will interpret the term such other circumstance which follows the general, which follows the specific words like war, lockdown, etc. So you have a legal principle called ejusdem generis, which means that general words following specific words will draw color from the specific words which they follow. Meaning, if you have, for instance, a situation where you have said a force majeure event includes a war, pandemic, natural calamity, and such other circumstances, then the term such other circumstances will be interpreted in the same manner and in the same contours as the first three words, basically meaning something beyond the control of the party, basically something akin to impossibility to perform. So it will not include business risk, it will not include commercial risk, it will not include price fluctuations, it will not include fluctuation in the price of raw materials, it will only include something which is external in the nature of impossibility. If you're not specifically provided, then it will only include those kind of aspects. So I'll give you a principle of ejusdem generis and a live case, in a sense, the case we have handled in the past, where a courts took a view and how they look at that. So this was a case which we had done. This was a case which we had done a few years ago in the matter of a SEBI aspect, a SEBI issue, where the takeover regulations of SEBI, which prevailing at that point of time, said that if an acquirer is acquiring the shares of a company, which is a public listed company, and he acquires a particular percentage of shares, he has to make an open offer to the general public to purchase a portion of their shares. And there was only one clause which talks about withdrawal of open offer, where in a case a party who is making an open offer wants to withdraw that, there were only three circumstances under which an open offer once made can be withdrawn. Namely, death of a promoter, statutory licenses not coming through, and such other circumstances which in the opinion of SEBI merit withdrawal. So it's exactly the same on the lines which we are discussing, where there is a general term which follows two specific terms. So now the facts of the case, what happened is our client was an acquirer and he was acquiring the shares of a public listed company. So he acquired those shares and he made an announcement for an open offer. So what happened is, after making of the announcement, he realized that there was a massive fraud, and therefore the company did not want to go ahead with the transaction. They did not want to invest. They did not want to go ahead with the open offer, and they wanted to withdraw that open offer. So what they did is, taking recourse to the provisions on withdrawal of open offer, they wrote to SEBI that there was a massive fraud which they did not know, and under the regulation, they could withdraw the open offer. So they asked for a withdrawal. However, SEBI refused, and this matter went from SEBI to the Securities Tribunal to the Supreme Court. And finally, the question was whether the term such other circumstances would include fraud. And the SEBI, the SAT, and Supreme Court all negated this argument and said that the term such other circumstances have to be drawing color from the specific words which precede it, namely death, statutory license not coming through, meaning something akin to impossibility to perform. So fraud will not absolve a party from its obligation to perform the open offer. So fraud can be determined by due diligence. So the court said that it has to be interpreted ejusdem generis. It has to be interpreted in terms of the existing words, and a narrow interpretation has to be given only to mean things of the same class or the same genus. So therefore, that's why I'm saying that it's important, to the extent possible, to specify within the contract what are the events which you would construe as a force majeure event, specify them to the extent possible, and do not leave it open to judicial interpretation, because then it's susceptible to arguments and challenges like the case I've just highlighted. So this is the first aspect on force majeure events. The second one deals with invocation of the force majeure clause. And normally it is done by way of a notice by the party who is suffering to the counterparty saying that I will not be able to perform the contract. For instance, because of the lockdown, many companies are facing this issue. It is difficult to perform their contract and their business obligation. So notice has to be issued to the counterparty in terms of the clause, where they tell the counterparty that they will be unable to perform because of this force majeure event. And time, as Napoleon once said, there's only one thief which steals everything from man, but yet law does not strike down, and that thief is time. Time is of the essence. Many force majeure clauses you see will have a time period which is specified within which you have to invoke that force majeure clause. So therefore, you will have a time period of 7 days, 15 days from the date of occurrence of the force majeure event, which affects the contract, within which you have to invoke that particular clause. If you miss the timeline, then obviously it will be difficult. The other side will argue that the remedy of force majeure will not be available to you. The third and possibly the most important aspect in a force majeure clause is the part which deals with consequences of a force majeure event. So normally a force majeure clause will not put the contract to an end. It will not discharge the contract at the first instance. The idea of the clause is to save and protect the contract. And what will happen normally at the first instance is that the liabilities of a party who is suffering will be suspended for the time being. The obligations of a party who is suffering will be suspended for the time being until the force majeure event abates. So that is one of the principal differences between force majeure and the concept of frustration, which we will discuss later, where in case of frustration, the contract is terminated and discharged. In case of force majeure, the contract is kept alive so that it can revive at a future date. But at the same time, the obligations of the suffering party are suspended so that the contract can be performed at a later date. Many a times in infrastructure projects like building of roads, ports, you will have time frames within which the project has to be completed. Many of these force majeure clauses provide as a consequence that the time frame which is lost due to the force majeure event will be extended. So a corresponding extension of time frame will happen subsequently after the force majeure event abates. Thirdly, and most important, is clauses will also provide that in case the force majeure event continues for beyond a particular period of time, then the contract can be terminated. So for instance, if the force majeure event continues for 90 days, 120 days, in such a case, the contract itself provides that the contract can be terminated and there will be no liability for the parties who are suffering under the force majeure event. So therefore, the part of the force majeure clause dealing with consequences of force majeure is perhaps centrally the most important aspect of this discussion to be kept in mind while drafting a force majeure clause. Finally, the fourth aspect is the aspect of mitigation, where, as we discussed, it's the bounded duty of every party to try and mitigate the losses occurring from a force majeure event. So therefore, a party cannot put up his hands and say, I'm not going to perform at all. Performance has to be done to the extent possible, and the relief will only be for that part of the contract which cannot be performed beyond a particular period of time. So therefore, trying for alternate means of performance, trying for alternate supply routes, trying for alternate transportation routes, trying for alternate staff, etc. All these alternate means of performance have to be explored, and the parties have to continue to perform a force majeure contract even in a force majeure situation, and it is not completely discharged. So that is a bounded duty of a party to mitigate to the extent possible the damage which is occurring. So three principles to be kept in mind. It has to be a defined event. It has to be beyond the control of the parties. And number three, it hinders the performance of a contract. So these three principles have to be kept in mind for the purpose of invocation of a force majeure clause. I'll give you a current case which was handled and the judgment which was passed few days back by the Delhi High Court. Now, it was a matter where an invocation of a bank guarantee was stayed in connection with the COVID-19 and lockdown, which was construed as a force majeure event. So just before we get into the facts of the case, I'll give you a background on the legal position in connection with invocation of bank guarantees. Now, the law in connection with invocation of bank guarantees is extremely rigid and strict. Courts, in the rarest of rare cases, will grant a stay on invocation of a bank guarantee. Courts are extremely reluctant to grant a stay on invocation of a bank guarantee. And there are only two legally prescribed situations, namely fraud at the time of creation of bank guarantee, or the second concept of irretrievable hardship to a party, where a court will normally even think of granting a relief for invocation of a bank guarantee. So this is a general law to deal with invocation of bank guarantee. Now we look at the specific case dealing with COVID-19, dealing with lockdown, and how the judiciary looked at that case from this perspective. The case is of Halliburton versus Vedanta, where Halliburton had undertaken to complete a development project for oil fields for Vedanta, and for the performance of which they had given some 8 bank guarantees. Now, what happened while the contract was being performed? The COVID-19 pandemic happened, the government lockdown happened, and therefore performance was very, very difficult. It was not possible to go ahead with performance. So Halliburton wrote a letter invoking the force majeure clause. So they had a force majeure clause within their contract, and told Vedanta that they will not be able to perform in light of the lockdown. And therefore, force majeure was invoked, and a request was made not to invoke the bank guarantees, which was in the possession of Vedanta. Since there was no favorable reply, Halliburton had to go to court, and they approached the Delhi High Court. And surprisingly, as I said, it's a deviation from the general judicial trend. The High Court looked at the current situation and they said, yes, this is a unique situation. This is not something normal. It is unprecedented. COVID-19 and the lockdown will be a force majeure event. And therefore, in this situation, it is just fair and equitable that the invocation of bank guarantee be stayed and an injunction was granted. As I said, this is extremely rare, but it gives you a flavor as to how the judiciary is thinking at the current moment, looking at the COVID-19, looking at the lockdown, and it gives us a general flavor as to how the courts are thinking, how the courts are interpreting, and the judgments which you will see from time to time have become relief oriented. They want to give relief. They want to help parties who are facing genuine difficulty in light of this lockdown. So therefore, these are the general aspects which cover a force majeure clause. And a question which keeps coming from time to time is what happens when there is a dispute. In a sense, if I have a contract and I invoke a force majeure clause on the basis of, say, instance, COVID-19 and lockdown, and the counterparty to the contract does not agree, they say that, no, this is not a force majeure event. What happens? In such a case, it will be left to judicial interpretation, and the matter can be taken to arbitration or the courts of law, depending on your contract, where the courts will decide whether or not COVID-19 and the lockdown can be construed to be a force majeure event. And they will look at the aspect on a case-to-case basis. They will look at our contract. In case we can be given a relief, it does not necessarily mean that the other contract for another party will also get the same relief. It is a relief which is granted on a case-to-case basis. So this is something to be kept in mind as far as the disputes are concerned. The dispute could be in connection with defining a force majeure event, or even the extent during which the force majeure event lasts. I may say it has lasted 3 months. You may say it has lasted for 1 month. And that aspect also has to be determined by the courts in case there is any particular dispute. Now, having discussed the contractual aspect of force majeure, as I said at the beginning of the talk, we will divide our topic into 2 parts. One is force majeure and the contractual aspects, and one is the doctrine of frustration of contract, which is a purely legal aspect and is purely something to do with law. As the saying goes, that there is no better way to exercise your imagination than the study of law. No artist can interpret nature as freely as a lawyer would interpret a contract. So when it comes to legalities, there's a lot of scope of interpretation, and the concept and doctrine of force of frustration has evolved over the last 70 years by way of various judicial principles given by various Indian courts, which have defined as to what would be a frustration event. So what comes out of it, what I will do is I will broadly, there are some 70 years of jurisprudence and number of case law surrounding this aspect. What I will do, I will start off by telling you the 5 or 6 judicially recognized principles under which a relief for frustration of a contract to discharge a party of its obligation will be granted. So these are 5 or 6 principles which have been culled out of number of years of judicial precedents. Thereafter, I will give you certain cases which have actually happened where the remedy of frustration of contract to discharge a party has been given, and other cases where it has been refused. So you will get a general flavor as to how a court will interpret this aspect dealing with frustration of a contract when it comes to, for instance, any kind of unforeseen event which is completely independent of the contract. For example, in a contract to do with manufacture of goods, you will not contemplate what can go wrong drastically if suddenly a natural calamity happens or there is a situation which is completely beyond the control of the parties where the entire purpose of the contract is lost. So that is where the situation is particularly important when there is no force majeure clause in the contract. So the entire previous discussion was where there is a contractual right of a force majeure clause. Now we are discussing a situation where there is no force majeure clause in the contract, and we are looking purely at a legal remedy of frustration of contract, particularly when you have not provided for a force majeure event in your contract. So here it is based on 2 Latin maxims. One is vis major, which is the act of God. It is unique how God always finds place even in our contracts. And the second is the legal principle of lex non cogit ad impossibilia, meaning that law will not compel performance of something which is virtually impossible. So the 5 or 6 principles which I was mentioning, one is that impossibility does not mean impossibility in the physical or the literal sense. It means the contract is impracticable to be performed. Secondly, frustration of contract and discharge for frustration is granted only in the rarest of rare cases. So the norm for the court is to uphold the contract and bind the party to performing the contract. And it is only an exception where the relief of frustration will be granted. Thirdly, the frustration events should be such that it should strike at the root of the contract. It is such an event which completely changes the balance or the equilibrium of the contract, and it strikes at the root or the basis of the contract. So it completely changes the contract as it once was and it once stood, and it into keeping in mind certain specific things to a completely different situation which is not contemplated by the parties. Fourthly, unlike force majeure, which also suspends the performance of a contract and gives relief in terms, it's almost like a contract on a ventilator where you're keeping the contract alive for some time. Unlike that, an event of frustration discharges the contract. It puts an end to the contract. It terminates the contract. So it is different from force majeure in this way, that it's something which puts an end to the contract. And finally, there has to be a level or an element of permanence in the event which is happening. In a sense, the event which we claim or complain to be a frustration event cannot be something which is temporary. So this point is going to be very important in connection with COVID-19 and the lockdown, whether it can be construed to be an event which can result in frustration of a contract, because it may not really have permanence in that sense. It could be a temporary event. And I'll tell you a real case which happened in Bombay in the matter of standard retail, where there was a contract for performance of a particular aspect. And because of this COVID-19, there were certain goods to be supplied, which was the steel to be supplied from Korea to India. And it had to be shipped, and it was already shipped. After the shipment had happened, the buyer in India said that now the COVID-19 pandemic has emerged and the government has imposed a lockdown, and therefore the contract is frustrated and I cannot perform the contract. However, when the matter went to the Bombay High Court, they negated this argument, saying that COVID-19 cannot be an event of frustration principally because COVID-19 and the lockdown is a temporary event. It is going to abate. It is going to be lifted. And therefore, you cannot really claim frustration of a contract, and the contract has to be performed. Unfortunately for the petitioner in that case, the contract related to supply of steel, and the government had declared that steel is an essential commodity, and therefore even this argument went against the petitioner. And therefore, as you see, it gives you a flavor where a remedy for frustration was refused by the court because they felt that there is no permanence in this particular issue, as we are talking about COVID-19 and the lockdown. So these are the 4 or 5 essential principles one must keep in mind, that simply because a contract becomes difficult to perform or onerous to perform, or the price has increased, or it is double as costly, or it is double as time consuming, it will not discharge a party on the ground of frustration. It has to be something much, much more. It has to be something which destroys the fundamental basis of a contract. And to give you an example of frustration, I will give you an example of a case which I had handled around a couple of years back, where we successfully established frustration of a contract and discharge. The case related to a port contract. So we are talking about Chennai port. And what happens in a port contract is every port has a number of berths where a ship comes and it will berth at that particular berth. So there are 10 or 15 berths where ships can keep coming for loading and unloading. So the situation was that in 2004 and 5, in Chennai port, there was so much traffic of vessels, there's so many ships coming in, that the ships had to wait in a long queue, and as a result of which there was a significant delay before they could even get a berthing at a particular berth. So one ship would come, it would take time for loading, unloading, and until it went, the second ship could not come in, and there was a long queue, and people had to keep waiting their turn for the purpose of loading and unloading. So that resulted in a lot of delay, that resulted in a lot of cost because of the heavy volume of traffic which was coming in the Chennai port. So what the government did is they came out with a scheme, and the scheme was called a berth reservation scheme, where one of those 15 berths would be given on a license for a period of 20 or 30 years to a licensee. And the arrangement was such that the licensee, which basically was our client, would pay the port trust an amount in advance every year towards berth hire and berth reservation charge. So he would get a reserved berth, and he could dole out this benefit to various shipping lines. So he would enter into a subsequent contract with a shipping line, giving them priority berthing for a premium amount. So if a shipping line is willing to pay a premium amount, he will give them priority berthing. So the benefit for the ship was that it will jump the queue and it will directly get a priority berthing, and he will not have to wait for a long time in a queue, and he can directly come and berth. And for that, he had to pay my client a premium amount, which was basically the profit element for the client. And as I said, for my client, the liability was to pay in advance to the port trust every year the entire berth hire and berth reservation charge. So he got a reserved berth, which could be doled out to other shipping lines for their benefit so that they can avoid a queue. So this was the business model which was in force. Now, in 2014, something very interesting happened, where the Madras High Court came out with an order in a public interest litigation saying that there will be a complete ban on any kind of dusty cargo like coal and iron ore coming into the Chennai port. So any vessel or any ship carrying dusty cargo like coal and iron ore will not be allowed access to the Chennai port. And a special port called Ennore port was established a few hundred miles away from Chennai, where all the dusty cargo like coal and iron ore would be handled. So the situation which emerged was such that almost 70 to 80% of the volume of traffic which used to come to the Chennai port got diverted to the Ennore port. As a result of which, all the 15 berths, they started to lie vacant. And therefore, there was no real need for any shipping line to avail the benefit of priority berthing. So no one really wanted to avail this benefit because there was no point of paying a premium to my client and availing a facility when that facility anyway was now freely available because there is no traffic whatsoever. They can simply go and berth at any particular berth. So why would they incur this additional expense? So this resulted in a complete failure of business model because unfortunately for my client, he had to pay an advance amount every year to the port trust. So we went to the port trust and made a representation that the fundamental basis of the contract is lost. No one is willing to take the benefit of berth reservation. Vessels don't need it. Kindly discharge me. And the contract is frustrated. And the port trust, however, as we know how the government authorities deal with it, they refused. So what happened was the matter was then taken into litigation. And finally, we succeeded. And the courts held that the contract was completely frustrated because the essence and the fundamental basis of the contract was existence of volumes of traffic, of number of vessels coming in. Only then someone will want to avail priority berthing. If there is no traffic, if there are hardly any vessels coming in, there is no need for this particular contract. So the fundamental basis of the contract was lost, and therefore it was declared that this contract was frustrated. So this is one of the rare situations where the fundamental basis of the contract itself was lost, where judicially we got a good decision, a favorable decision, discharging our clients from a very onerous contract where the fundamental purpose was lost. Another example where the relief of frustration was granted is the case of Delhi Development Authority versus Kenneth Builders, which was a Delhi High Court case initially, which went to Supreme Court. The Delhi Development Authority had floated a tender for the purpose of development of a plot for housing economically weaker sections of the society, and they needed a builder to develop it. So public tender was issued. Kenneth Builders emerged as the lowest bidder, and a development agreement was signed. And under the agreement, it was the obligation of Kenneth Builders to seek the licenses of the governments for the purpose of starting the construction. Now, when Kenneth Builders went to seek licenses of various government bodies like the Pollution Control Board and various other statutory authorities, they were refused. The government refused to give the license because of certain issues. And Kenneth Builders went back to Delhi Development Authority saying the contract was frustrated. I cannot commence construction because the license is not forthcoming. Delhi Development Authority, as I said, how government authorities deal with it, they refused. The matter went to the High Court and eventually to the Supreme Court. And both the courts in one voice held that the contract was completely frustrated because despite all efforts Kenneth Builders had put in, the license was not forthcoming, and therefore there could not be any possibility to commence construction. So there is no point of continuing with this contract, and the contract was discharged. So these are the two instances which I can give you. There are many others also, but of situations where the remedy and the relief of frustration was actually granted by the courts. However, this is not the norm. This is the exception. And now, when we talk about the norm, basically courts refusing to grant a relief of frustration, you will find hundreds of cases from 1954, starting with the first case of Ghosh versus Bangar, and ending in 2017 with another landmark case, which we will discuss in a moment. So the first case, which was a 1954 case of Bangar, was a case for sale of a plot of land for the purpose of development. And After the agreement of sale was entered into between the buyer and the seller, there was a requisitioning order by the government because of the war effort, and the land was requisitioned by the government for the purpose of war. So the seller wrote to the buyer saying that now the land has been acquired by the government, it has been requisitioned by the government, and therefore the contract is frustrated, and therefore there is no point of going ahead. So kindly discharge the contract. However, the buyer sued and he went to court asking for specific performance of the contract. And surprisingly, as it sounds, the court held in the favor of the buyer, saying no, the contract is not frustrated because requisitioning is a temporary event, war is a temporary event. The contract could still be performed. There was no timeline stipulated within the contract. And therefore, there is no relief of frustration, there is no frustration, and the contract continues. So this judgment of Bangar laid down a trend, as you see, of various other judgments which were to subsequently follow, where the judicial trend even today continues. Frustration is an exception, binding the parties to the contract is the norm. And if you see the line of judgments, I will only discuss one more, which is a landmark judgment of 2017 by the Supreme Court, passed by one of the most brilliant judges, Justice Rohinton Nariman, in 2017 in the matter of energy watchdog. So what happened in that case was it related to power supply agreements, where after pursuant to a public tender, a power purchase agreement was entered into between government entities and power suppliers. Now, the business model, the power suppliers, when they bid, they had in mind was that they will procure coal from Indonesia because the coal was very cheap. Coal is the raw material you need to basically generate power. However, after entering into the contract, because of a change in Indonesian law and policy, the price of Indonesian coal skyrocketed. And therefore, it was very difficult and onerous and commercially unviable for these power purchase or the power suppliers to go ahead with this contract at the current rates. And therefore, they asked for a remedy of discharge. And the matter went into litigation. They prayed for frustration. However, Supreme Court and Justice Nariman said there is no frustration. The fundamental purpose of the contract is generation of power and electricity. And there is nowhere in the contract where it is stipulated that you will only use Indonesian coal. You might as well go ahead and procure coal from any other alternate source, even though it may be twice as expensive. So, as I said, even though it was very expensive, even though it was onerous, Supreme Court bound them to their contract. They did not give the relief of frustration because an alternate mode was available. They could have procured coal from somewhere else. And there was nothing in the contract which said that it has to be only Indonesian coal. They also said that a change in law remedy which the parties were seeking can only be for a change in Indian law, and they will not get the benefit seeking change in Indonesian law. Interestingly, while deciding this case, they relied on a 1962 case of the House of Lords in England, where a case was decided where the contract was for shipment of certain goods from one country to another. And normally that time, the Suez Canal was used for the purpose of transit. But in 1962, because of certain war and other events, the Suez Canal was closed. And the shipper filed a case seeking frustration of the contract, saying, I cannot use the Suez Canal and therefore the contract is discharged. However, the court refused, saying there is no frustration because an alternate route was available around the Cape of Good Hope. And even though it was twice as time consuming, even though it was twice as expensive, the court held the parties to the bargain and said that there is no frustration. So this is the trend which has evolved over a period of time, where case after case you will see that courts refuse to grant remedy of frustration, and it is only in exceptional cases. We already discussed the case which was decided by the Bombay High Court, where they refused frustration on the ground of COVID-19 and lockdown. As I said, because it's a temporary event. For a frustration, which is a much larger remedy, it's a legal remedy, you need something far more drastic than a COVID-19 or a lockdown for a contract to be discharged. And as I said, it has to be evaluated on a case-by-case basis whether the remedy will apply or not. The third aspect today, what we will discuss, is a very novel concept of something called renegotiation clauses or change in law clauses in an agreement. This particularly applies for long-term infrastructure projects like a road project or a port project which span for 20 years, 30 years, where you do not know that maybe 10 years down the line, there could be a change in law which would substantially change the contract. For instance, if a new tax regime is introduced 10 years down the line, my commercials can completely go haywire. And I have not contemplated for this possibility. So that's where the change in law or renegotiation clause comes in, where it says basically that after entering into a contract, if there is a change in law which substantially affects the commercial viability of a project, then the parties have to renegotiate and the contract can be amended. So it is an inbuilt contractual provision which provides for amendment of a contract as agreed between the parties by way of this clause. So it's a very novel concept. It is not really tried and tested in India, but internationally, it is something which is quite recognized. And a question which comes from time to time is what happens if the parties are unable to agree to a changed contract? What happens if the parties are unable to renegotiate and change the terms? And the answer lies in the United Nations principles of the UNIDROIT, where they envisage a very similar situation while discussing a change in law clause and say that after a change in law, post entering into the contract, if the parties are not able to come to terms, then the matter will be referred to arbitration or court litigation, and the courts and the arbitrators can rewrite the contract, they can amend the contract and adapt the contract to the changed circumstance so as to restore the equilibrium of the contract and to basically distribute the losses of the contract. So the arbitrators and the courts have been given the power to carry out a change in the contract, which otherwise in general jurisprudence in law, the general norm and the principle is that courts can never rewrite a contract for a party. It's the realm of discretion of the parties. The courts will never interfere drafting contractual terms. But this clause is a unique exception which provides discretion to the courts and arbitrators to adapt or amend or change the contract terms if there is a change in law after entering into the contract. In the last few days, we have seen the government taking a number of measures in view of this COVID-19 and the lockdown. And I'm not talking about opening up of alcohol shops for boosting revenues. I'm talking about something far more concrete. And these include steps, for example, the Ministry of Finance has issued a notification saying COVID-19 is a natural calamity, and therefore this should construe as a force majeure event for the purpose of contracts. Similarly, the Ministry of Shipping has issued a notification to various ports and port trusts saying that COVID-19 is a force majeure event and that benefit should be given to parties who invoke force majeure for COVID-19. They've also told the port trusts not to impose penalties on port operators whose performance is hindered because of COVID-19 and the lockdown. The Reserve Bank of India, which is the country's national banking regulator, has also issued a circular calling for a moratorium of 3 months for payment of loans, installments of which are due after 1st of March 2020. So that is another relief in terms of loan agreements, etc. And this benefit has also been extended for the purpose of declaration of non-performing assets. So this 1st March 2020 cutoff will even apply for that purpose. Thirdly, the Insolvency and Bankruptcy Code, even as we speak today, there was a discussion that the government is mooting an idea of suspending the operation of the Insolvency and Bankruptcy Code for a period of 6 to 8 months because of this COVID-19 pandemic and the lockdown, where once the lockdown is lifted, many companies are likely to face payment issues, recovery issues, and therefore there'll be a flurry of cases which will be filed before the NCLT. And therefore, they're mooting the idea of suspending the operation of the Insolvency and Bankruptcy Code for a particular period of time so that companies will get some relief to restore their abilities, to restore their functioning, and they will not be subjected to insolvency proceedings. We have a very active judiciary, and Supreme Court too in March has passed an order which says that the period of limitation for filing of cases before various courts and various proceedings will be extended, and the period of the lockdown will not be taken into account for the purpose of computing this period of limitation. So this is substantial relief to parties who are looking to file cases before various courts for various statutory provisions. So this is also something which the courts are doing. As you all know, the judiciary is actively functioning, hearing extremely urgent matters by way of video conferencing. So in that sense, the entire arm of judiciary is currently engaged imparting justice even as we speak. The next aspect, which we'll briefly touch upon, is the payment to employees. And in this regard, for various companies, and this is particularly important for small scale industries and other business units. And there are two important aspects which have to be considered. One is an advisory of the Ministry of Labor on March 20th, which says that companies should continue to pay without any deduction salary and wages to workmen and employees. This is an advisory. It does not have the force of law, and it's generally in terms of an advice from the government. The second one is something which is more important, is a notification under the National Disaster Management Act on 29th of March 2020, where the government has issued a notification, the Ministry of Home Affairs, saying that workers, including migrant workers, should be paid in full and there should be no deduction. So this, unlike the previous one, is not an advisory, it is a notification having force of law. And the situation, the on-ground reality and situation, even as we speak. Now, what happened pursuant to this is there are two lines of petitions which were filed before the Supreme Court. One was by employees who went and filed petitions before the Supreme Court saying that the employers are not adhering to these notifications and they're still cutting salaries, they're still cutting wages. And one by a group of employers, including small industries, who have gone to the Supreme Court saying that it is virtually impossible for them to make these payments where there are no revenues. The Supreme Court has taken notice of the matter and they've issued a direction to the government to come back with a concrete reply within a period of 2 weeks. So we'll get to know within 2 weeks what is the government's position on this particular aspect. So this is something very important which we will get to know. It will be clarified very soon as to what is the position in connection with payment of wages to workmen, which in that sense is a mandate under the National Disaster Management Act, and what kind of relief is envisaged by the Supreme Court for the purpose of employers and for the purpose of employees who are subject to these aspects. The other aspect, the question which keeps coming, is in the context of rent agreements. Here, the question is whether a licensee is still to pay rent or license fee to the landlord during the lockdown and the pandemic. So the fundamental point, the first thing to look at is your individual license agreements and your lease agreements to see if there is a force majeure clause. And if that force majeure clause gives you any kind of suspension or any kind of relief from payment of rent in the case of happening of any force majeure event. If there is no force majeure clause, then unfortunately the position is that in that sense, legally, there is no relief. The landlord would be right to demand the rent. And in that sense, frustration may not really apply in this particular factual matrix. What we have seen is, for instance, the government of Maharashtra again has issued an advisory. It doesn't have the force of law, but has issued an advisory to all landlords to defer collection of rent for a period of 3 months. But as I said, it has an advisory, doesn't have the force of law, and we'll have to see in the days to come how these aspects are dealt with. So I think we are coming to an end to this first half, and what I would say is in this situation, which is an unprecedented situation, it is important for all of us to get together and try and work out solutions amicably, inter se between the parties, rather than taking matters into litigation and to courts. As one knows, litigation is a legal right which ensures that every corporation spends at least a decade in court. And therefore, it is imperative in that sense to work out via medias, to work out compromise solutions, and try and see that matters do not escalate. Everyone is facing difficulty. We are equal participants in this, and therefore to try and resolve all issues to the best extent possible. As you know, a bad compromise is better than a wonderfully looking lawsuit. And therefore, compromise in that sense is a formula. A give and take solution can be worked out. In the rent example which I gave, a compromise can always be worked out where the obligation can be deferred for some time, or it can be adjusted against the security deposit. So various options and via media are available, but these are all in the nature of contract and inter se agreement between the parties, and it does not really have the force of law in that sense. But as I said, it will obviate the need to really take matters into litigation, and which is obviously, as we know, quite expensive and time consuming. Now, one important thing that comes to the mind is what the example which has been set by the Singapore government. The Singapore government has passed a legislation known as COVID-19 Temporary Measures Act, where they have given a moratorium of 6 months from invoking any kind of commercial litigation, suits, arbitrations, or insolvency proceedings in connection with certain contracts like construction, loan agreement, media, entertainment, tourism. So they have categorized a category of contracts, and they have said that there be a moratorium of 6 months. For 6 months, there will be no litigation initiated in connection with these contracts. So this gives an ample opportunity for parties to work out their differences, to work out all what is amiss and try and fill the gaps, rather than taking matters to litigation. And something can be learned from the example set by the Singapore government, which can be seriously considered, that everything need not be taken into litigation. There can be a moratorium for a period of 6 months where parties can be given an opportunity to try and work out all their differences if that is possible, because that is obviously in the interest of everyone who is a party to the contract. Ladies and gentlemen, as they say, trade and commerce is like Indian rubber. It always bounces back from whatever challenge is thrown to them, be it a regulatory challenge or be it a challenge in the nature of a pandemic that we are currently facing. I'm sure that all of us will very soon bounce back. Thank you very much for a very patient listening. I will now turn the attention and request Neha, my colleague, to introduce Mr. Krishna Joyce, who is from Alcon, which is a company related to Novartis, to give you all a first-hand account of what the industries are facing. After Krishna, there will be one more speaker, and then we will open up the debate to a question-answer round where we will answer as many questions as possible, which we have been getting. Thank you very much for a very patient hearing.
Thank you, Zerick. I have also had the opportunity of working with Krishna and our next speaker, Manjunath. I welcome them. Mr. Krishna Joyce is currently the head of legal and compliance for Alcon India and Southeast Asia cluster. His role covers all matters connected to legal, ethics, compliance, data privacy, and corporate secretarial. Krishna has worked in the USA, Switzerland, and parts of Asia. Krishna has work experience in the IT, pharma and healthcare, logistics, infrastructure, and hospitality sector. Krishna has previously worked with companies like the Opto Circuit Group, Strides, Arcolab, and Wipro ePeripheral. Krishna, over to you.
Thank you, Sneha. I think Zerick made a very good session, and it makes mine and Manjunath's life. Manjunath is also a good orator, so life difficult to kind of keeping the attention of the people. Anyway, thank you so much for having me, and thank you, Mr. Tantra, for having me as well. So, from a business and an industry point of view, I'm not going to touch upon the legal aspects, which Zerick has well explained with appropriate examples. From the industry side, how in-house is feeling, and probably what are the measures which big setups are taking at this point of time, which I would want to share, and probably what are the things probably medium and small scale industry can also, or setups can also think. At this juncture, the COVID looks like scientific fiction movie, right? So it looks like you are part of which you don't know when you are going to get out of the situation, when it's going to end. It's not very clear. So having said that, probably if you are not going to take control of the situation and probably manage your stakeholders, probably you will end up into bigger litigation. As Zerick mentioned, the litigations are not going to be a very easy cakewalk. It's going to be quite a difficult task for both the parties, and probably the winner may not really celebrate the victory as well. So some of the things probably the big corporates are looking at this point of time is the collection, especially the sector where I'm working, the hospitals and the clinics or healthcare organizations are not generating the money they were generating, right? So obviously they'll not be able to repay the money to you. So I think it may be the same case with others. The customers whom you are dealing with, probably your receivables are stuck. So you may have a very strong force majeure clause, or you may not have. But to avoid litigation, and also kind of this will look like a more a good gesture appearance from your end, probably you can reach out to your customers and probably extend the possible moratorium from your end. It could be in a different way. It could be extension of time. It could be kind of taking a part payment, or it could be in multiple ways. I think depending on the financial capabilities one and each organization has at this point of time. At the same time, the supplier whom you are dealing with, they will also have money receivable issue from their end. So it would also be advisable you manage the discussions well, and probably have appropriate arrangements so that you don't get into a litigation at a later stage. And it goes without saying that when you are getting into this kind of arrangements, this would be more like amendment or an arrangement which you need to document it well, so that you don't get into an issue of interpretation, or you don't get into issue of getting into arguing with each other at a later stage. So please go through your key stakeholders whom you feel are very relevant in terms of commercial transaction. Please list them out and probably have appropriate arrangement with them, so that yourself as well as the other party can agree upon, and you have a win-win situation. Before that, please look into your contract and understand your position. Many a times your contract may be very favorable to you, and probably you know how to bargain it better. Many a times the contracts may not be provided with a very strong force majeure clause, and as Zerick explained in detail, enforcing doctrine of frustration is not easy. So it would be good on your part to use that and probably bargain well and settle your thing, so that tomorrow you don't run into litigation. As Zerick mentioned, again, I'm quoting Zerick a lot of times in my oration, because Zerick covered the most of the things. Again, we're just sharing from an industry point of view, or from the in-house angle point of view, how does it look like? So there are laws in Singapore, there are laws in parts of Europe which gives part moratorium to the business. Rather, the clock stops, right? So the clock doesn't move, and probably people have absolute privilege or the right to say that, hey, look, I'm not going to perform this contract. But in our case, in India, the law is not very well settled. It is in the process of coming into coming into a situation where you can probably understand and probably follow it. The labor matter is before Supreme Court, and probably in a couple of weeks we will have clarity. The same way, each thread is going to kind of unveil. But it's going to be a longer time to kind of say that when the law will get settled. Before that, probably it would be ideal if we engage with our stakeholders and settle our contracts in a right way, that so that you don't get into litigation at a later stage. It goes again without saying that please consult your lawyers and auditors as the need be when you are doing your math and probably understanding your legal position. That would certainly help you in negotiating with your clients. And I wish that this situation ends sooner and we all be out of lockdown and all this situation. That's what the final note with which I complete and I share my experience. Thank you.
Thank you very much, Krishna, for your views. I'll invite our next speaker, Mr. Manjunath Chandrasekhar. Manjunath is presently the Chief Legal Officer at Hungerbox, which is in the space of institutional food technology. Manjunath's role at Hungerbox includes all legal, secretarial, compliance, and regulatory matters. Prior to Hungerbox, Manjunath has been a part of legal teams of many companies like Black Buck and Toyota. And before he took up in-house roles, Manjunath was a practicing lawyer with a Bangalore-based law firm. Manjunath, over to you.
Thank you, Sneha, for the introduction. Good evening, everyone. Zerick, very interesting and thought-provoking. Well, I'll give you all the industry perspective as to what we are facing. Before that, I'll just give a brief background about Hungerbox, because not many would know what space we are into. Like Sneha called out, we are an institutional food tech company where we primarily work with corporates and tech park, managing their cafeteria and food supplies. When we say we manage cafeteria, we curate food vendors, we carry periodical audits, ensure hygiene check. We also manage the compliance in accordance with regulatory standards prescribed by food authority and other regulatory bodies. So the employees of corporates can seamlessly use cafeterias, order food, and make life of corporates and vendors easy so that it plugs the leakage. Well, sharing our industry experience about impact of COVID-19 and lockdown. Since the day the lockdown was announced, like many and most of our operations have come to a standstill. And you all know that cafeteria and restaurant industries have been hit the most. So in this situation, like any other startup, our primary motive is to conserve cash and effectively manage cash flows. So we have targeted two of our major overheads, one real estate rentals, two salary. So coming to real estate rentals, we have reached out to many of our landlords seeking for waiver of rent. Some have agreed, and some have agreed to cooperate and give a part waiver, whereas some have denied. So we are exploring options to invoke force majeure and seek exemption from performance of our obligations. Speaking about salary overheads, we are exploring options to enforce pay cuts, retrench, and lay off a couple of workforce. We are evaluating what are the implications of the same. Say, if we retrench, what should be the compensation payable, and can we retrench people when Ministry of Home Affairs guidelines are in force?
These are a couple of legal issues which we are evaluating. Zerick has very well covered these topics in detail. Now, speaking about the countermeasures that we are taking as an organization to overcome the impact. So we are trying to redesign our product to make it COVID-19 viable or COVID-19 proof by ensuring social distancing norms and other hygiene checks. Similarly, we are renegotiating contracts with certain stakeholders to minimize the cost impact, and are also brainstorming other revenue models. So definitely, COVID-19 has impacted our business and making us to think aloud. And accordingly, we're exploring various options to stay afloat. That's about my experience about the industry. Once again, thank you, Zerick and team, for covering most relevant legal topics, which was need of an hour. And I'm sure many of the general counsels like me would have benefited. Thank you all. Stay safe.
Thank you, Manjunath. Thank you, Krishna. Zerick is now going to be taking the question answer session. Zerick. I think he's still on mute.
Hello. So we will quickly take the questions. Now there is a question from Khushbu Jasani. What is the effect of force majeure and minimum guarantee payment obligation where the corresponding supply obligation is suspended and the agreement is silent? So necessarily in a force majeure situation, your rights will be determined in terms of the contract which you've entered into. So your contract, if it's very, very express, by expressing certain events, you are necessarily keeping the other aspects out. So that is a possible interpretation. But what will happen if a force majeure event affects one obligation, it probably also affects the other. So that will be an argument in your favor. In addition to the legal argument, if it is applicable for frustration, if the event is so drastic that the entire obligation is in that sense impossible to perform, that you can also avail the remedy of frustration. There is a question from Zarir Khambata. What if there is no force majeure clause like we discussed? If there is no force majeure clause, the contractual remedy of force majeure will not be available, and you will have to take the legal remedy if at all available. Because as I said, the standard there is very, very high. The bar there is very, very high. And it is only in exceptional cases that a remedy will be granted. And therefore it is important. And that's one of the purposes of our discussion today. Looking at contracts in future, it is important that whenever you are framing these contracts, you provide for a proper, crystal clear, exhaustive force majeure clause, so that we are not dealing with a situation of uncertainty where we leave it to judicial interpretation as to whether or not a remedy is to be granted. If a force majeure clause does exist, you will get the remedy in the nature of that particular clause. There is a question from Korean Joseph, that even if the contract specifies time and procedure for invoking force majeure, is it necessary in the case of COVID and the lockdown, as is the existence is known to everyone? The answer is yes. You have to comply with the mandatory provisions of a contract. You have to disclose, you have to narrate, you have to be express in what you're looking at, because you cannot leave it to subjective interpretation. You have to specify what is the event that you are complaining about, because finally, if it goes into litigation, it will be gauged on the basis of what you have really invoked, the reason for which you have really invoked, and all the necessary consequences which will follow thereafter. Is the payment, there's a question from Viraf Debu, is the payment of wages compulsion, also an advisory. So here the situation is as such that the advisory which has been given is in connection with the Ministry of Labor, which had issued an advisory for payment of wages and salaries to employees, which was an advisory. But thereafter, what followed on 29th of March was a notification under the National Disaster Management Act. And that is not an advisory. That is a notification which has the force of law. And in that sense, it is, yes, it is a notification which is enforceable, penal consequences can follow, and therefore it is something to be kept in mind. So it has the force of law. The particular notification on 29th March, where payment of wages to workmen, including migrant workers, has been made compulsory. There's a question from Rubia. If the Finance Ministry has said COVID-19 is a natural calamity and to be construed as force majeure, then whether a party can invoke the clause of force majeure? The answer is yes. The Finance Ministry notification will act as a guidance for the purpose of interpretation whether pandemic of COVID-19 would amount to a force majeure event. And therefore, if that has been specified, your task has been made easy, where the Finance Ministry itself has said that COVID-19 is a natural calamity, and therefore, even though you may not have specifically provided for a pandemic in your force majeure clause in those specific words, it is unlikely you would have provided. Now you will provide in the future. But since you may not have provided, this circular helps you in that sense for the purpose of interpretation, where you can invoke force majeure on the ground of COVID-19 and the lockdown, which has been recognized by the Finance Ministry. Once the force majeure clause is invoked, till what extent, till what time frame are the rights and liabilities suspended? The answer is until the force majeure event abates. So until the force majeure events completely is over, the rights and liabilities are suspended and the contract remains in suspension. So I think we have covered many of the questions. What is the position when contracts states general force majeure clause to apply? So generally, if you have a clause which talks about force majeure without specifying the events, in that case, it helps a party because then it has to be determined on a case-by-case basis as to whether or not the event which is complained of actually impedes and hinders the performance. If it actually impedes and hinders, then that will be construed to be a force majeure event. If not, then it will not. So it depends on a case-by-case analysis. Therefore, as I recommended earlier, do not leave it general, do not leave it vague. Try and be as specific as possible. Try and be as exhaustive as possible while you're dealing with this kind of a situation. Try and provide for all the eventualities. Of course, you cannot provide for everything possible, but to the extent possible, do keep your clause very, very express. There's a question from Karthik. By invoking force majeure clause, can we terminate the contract which is valid for future period? As I discussed, normally in a force majeure clause, termination is not the first remedy. Of course, the first remedy is to try and protect the contract. It is to try and save the contract. It is to suspend the obligations. However, if the event continues beyond a particular period of time, then of course, the remedy of termination many a times is built in within the force majeure clause, where it can be terminated, it can be put to an end. There's a question is, when will the notice have to be issued? At the time of happening of a force majeure event, or at the time it affects the performance of a party? And the answer is, again, it depends on the interpretation of the clause, but many a times, logically, it will be from the time it starts affecting the contract. For instance, in a COVID-19 lockdown situation, you may fall under the essential commodities segment, and therefore you may not really be affected. So until and unless there is a direct impact on the contract itself, time will not start running. You cannot just say that there is a pandemic or a lockdown and therefore I'm availing this benefit of force majeure. However, as soon as it starts affecting your contractual obligations is when the force majeure clause will be triggered. So the answer is, it is at the time when it affects and starts affecting the contract that force majeure will be triggered. I think we've covered many of the questions. What we'll do is, if there are any further questions, I will request Mr. Yazdi Tantra to put in my email ID, and I will also type it here in the chat box. You are all free to send me your questions by way of an email, and we will try our best to answer these as soon as possible. So feel free to send me your questions. I will try and answer it. I think we have answered most of the questions on the group. Now, whatever additional questions or queries you may have, feel free to email me and I will respond at the earliest possible. Thank you very much for your kind attention, your patience, for a detailed session. Thank you, the organizers, Mr. Yazdi Tantra in particular, Consumer Resources, Online Comtech, and all the others who have supported this event. As I said, this is an unprecedented situation. This is something which is not normal and which is going to define our new normal. And how we cope with this is something which will define the future of commercial contracts and commercial litigation in this country. Thank you very much and look forward to see you all soon.
Thank you very much, Zerick. I was really impressed by the depth of the session and the lucid way in which you conducted the entire session. It's so many case laws and so many insights with your vast experience. As Zerick mentioned earlier, for more questions and information, you can write to him at zerick@zdlegal.com, which is his email address. Just for information of the participants, we are having another session tomorrow on Google Keep at 9:30 p.m. at the same link. So for lawyers, keeping notes is a very important thing. And if you are able to keep notes electronically, you will be able to find them much faster and much easier and years later. So be sure to join this session tomorrow. It will be real fun. Thank you. Thank you and good night. Anyone wants to say anything? Please type in the chat window. I can unmute you. Okay then, good night. Wish you all the best. Stay safe, stay protected. Bye.